Plaintiffs in the challenge to Illinois' gun and magazine ban, pushing against the state's request that the appeals court issue a stay on a district court judge's ruling the law is unconstitutional. Good morning. It's Illinois in Focus Daily after Thanksgiving. I'm Greg Bishop, and on Friday, you had the plaintiffs in the case respond to the state's request for a stay in the challenge of Illinois' gun and magazine ban, where district court judge, federal judge, Stephen McGlynn, ruled that the state's gun and magazine ban was unconstitutional. It is Illinois in Focus Daily. We've been tracking the gun ban litigation all the way through. I was even in the federal court for the 4-day bench trial that took place several months ago in the district court, which ultimately led to District Judge Stephen McGlynn 3 weeks ago saying that the law was unconstitutional. But on his own, he decided to put a stay on that permanent injunction against the law, giving the state 30 days to file an appeal. So now you've got the appeals court having taken this up now, and I do want to correct the record for us here with Illinois in Focus Daily. For the appeals process, I didn't realize that they had filed a separate case number for the 7th Circuit U.S. Court of Appeals, and that was filed on the 15th. So let's get into this, all right? So I've got the state's request for a stay in the appeals court, and then the plaintiff's response to that request for a stay while the appeals court deals with this case. So November 8th, that's when federal district judge Stephen McGlynn struck down the law, but put a stay on his ruling. The state filed their intent to appeal in the district court that day. Now, officially, the state appealed to the 7th Circuit U.S. Court of Appeals on November 12th. 2 days later, the federal appeals court, they said that a preliminary review of the short records indicates that the judge in the case, the judgment was deficient. They said that a judge must provide relief to which the prevailing party is entitled. In particular, federal civil rules of procedure require, among other things, that an order granting an injunction states its terms specifically and describe in reasonable detail the acts restrained or required. The injunction must be set forth in a document separate from the court's opinion. It goes on to say that the separate judgments entered in these cases fail to provide any relief and merely states that judgment is entered in favor of each of the plaintiffs against certain defendants. Accordingly, it's further ordered that both the appellants and appellees shall file on or before December 2nd, so today, a brief memo stating why this appeal should not be remanded to the district court to enter a proper judgment. Briefing is suspended pending further court order. Again, that was on November 14th when the appeals court said that the judgment was deficient and gave both the state and the plaintiffs in the case until today to file memos why they say it shouldn't be remanded back to the district court for what the appeals court says was proper judgment. But regardless of that, the following day, so November 15th, the state files a motion for a stay in the district court's ruling. So let's go ahead and pull this up because this is the document that the appeals court has in front of them from the state, spelling out what they argue is the rationale for having a stay. So they say that the court's decision is badly flawed in its injunction and should be stayed pending appeal. The opinion below fails to faithfully apply this court's decision in Bevis. Indeed, it repeatedly criticizes Bevis. The state goes on to say it cannot be squared with the Supreme Court precedents or the uniform decisions of the courts of appeals applying such precedent, and it would threaten public safety by permitting military-grade weapons to proliferate again in Illinois. The state went on to say in their filing, the court reasoned first that plaintiffs had shown that assault weapons and large capacity magazines, LCMs, are arms within the meaning of the Second Amendment, reasoning that they are owned by millions of Americans and so are in common use, and that assault weapons are not military weapons, given that such weapons can be used in automatic and burst mode, while automatic assault weapons available to civilians cannot. So they're essentially reiterating what the judge had to say. The court should stay the injunction pending appeal, the state says. Defendants are likely to succeed on the merits because the district court's opinion fails to faithfully apply this court's opinion in Bevis and breaks with the unanimous view of the federal courts of appeals that similar regulations on assault weapons and LCMs are consistent with the Second Amendment. The state further said that it is, if it's allowed to take effect. Moreover, the court's injunction will work serious and lasting damage to public safety within Illinois. Defendants request that the court stay the injunction by December 9th, the date on which the district court's stay expires, or administratively stay the injunction pending its further review. So we're getting into some interesting things here where, you know, the legal procedures in these cases being kicked back and forth. You know, should the appeals courts kick the case back down to the district courts in order for the district court to give a clear judgment that the appeals court says isn't being made by the district court? Or is the appeals court going to issue a stay come December 9th? So we've got a couple of different things working here when it comes to the status of Illinois' gun and magazine ban. But further, let's go into some more of what the state has to say here. They say defendants are likely to succeed in the merits. They say plaintiffs failed to show the assault weapons and LCMs are arms covered by the Second Amendment. B, they say the act is consistent with the history and tradition of prohibiting dangerous and unusual weapons. They say that the Fourth Circuit upheld Maryland's assault weapons ban because it was consistent with a long historical tradition of regulating those weapons and were invented for offensive purposes and were ultimately proven to pose exceptional dangers to innocent civilians. The state went on to say that the equitable factors tilt strongly in favor of a stay. Specifically, the damage done to the state and the public interest by a statewide injunction would be significant, while the damage done to plaintiffs by preserving the status quo pending appeal would be minimal. So essentially they're saying that keep the status quo of the law being in effect because the impact on plaintiffs would be, quote, minimal. The breadth of the injunction compounds the harm it'll cause if not stayed. For the second time in 2 years, the state says that the district courts issued an injunction barring enforcement of the act anywhere in the state. The courts did so without making any findings that a statewide injunction was needed to protect plaintiffs' rights, despite this court's instruction that universal injunctions will be appropriate only in rare circumstances. The state goes on to say that the court likewise enjoined defendants from enforcing the act's registration requirement despite conducting no analysis as to the constitutionality of that requirement and the fact that even the Bevis dissents would have found it constitutional. The court justified this decision, the state says, on the ground that the statute, in its view, is facially unconstitutional and not severable, even though it conceded that plaintiffs had not expressly sought such relief. By contrast, the state argued that the threat is of irreparable harm to plaintiffs if a stay is granted pending appeal is minimal. The purpose of a stay pending appeal is to preserve the status quo while litigation proceeds. And plaintiffs, for their part, have not shown, the state says, they will face irreparable harm while the appeals proceeds. They will continue to be able to obtain a wide range of handguns, shotguns, and other weapons for self-defense, including many semi-automatic firearms, and those plaintiffs that own assault weapons and LCMs can continue to possess them. They say in the end, plaintiffs cannot show their interest in obtaining additional lethal weapons is sufficient to overcome the significant interest of the state, and the state have to protect Illinois communities from assault weapons and LCMs pending resolution of this appeal. So that's what the state had to say in their filing for a motion to stay pending appeal. So let's now again get back to the timeline here. So October 19th, November 19th, an order was issued regarding motion to stay injunction pending relief. The appellees shall file a response by November 27th. So that was on Friday. Well, Friday, you have that motion being filed by the plaintiffs in this case, and we'll pull that up so that you can see the case number and such. So here is the plaintiffs filing from Friday, and they go on to say that indeed the Bevis court expressly declined to rule out the possibility that the plaintiffs will find other evidence that demonstrates that its preliminary views were mistaken. So they're talking about the Bevis court, and the appeals court, noted in particular that evidence regarding the construction, function, and application of the Firearms and Magazines, the Protect Illinois Communities Act bans, plus better data on their firing rates, might draw a sharper distinction between the weapons, PICA bans, and those traditionally reserved for military service, and in fact, might change the analysis altogether. That is precisely what happened, the plaintiffs say. On remand, the parties developed the more comprehensive record that this court contemplated, and one of the most comprehensive records in any Second Amendment challenge post-Bruin. The plaintiffs go on to say that the district court found, as a matter of fact, that the Firearms and Magazines PICA bans are arms that ordinary people who would keep at home for purposes of self-defense, as opposed to weapons that are not possessed for lawful purposes, are not exclusively or predominantly used in military service, and thus not only are arms under the Second Amendment, but cannot be banned, consistent with this nation's historical tradition of firearm regulation. The state had its chance to prove its case, plaintiffs say. It failed. There's no reason to give the state a reprieve and allow it to continue violating the Second Amendment any longer, the plaintiffs say. All in all, PICA bans nearly 1,000 rifles and shotguns, including the most popular models. They go on to say that a stay pending appeal is extraordinary remedy that should issue only in extraordinary circumstances. The court is essentially being asked to second guess on a highly truncated timeline the extensive record, briefing, and argument the district court considered after a trial on the merits. The party seeking a stay, the plaintiffs say, the state must show that it has a significant probability of success on the merits, that it will face irreparable harm absent a stay, and that a stay will not incur the opposing party and will be in the public interest. The state has not made such a case for a stay. They go on to say, contrary, the district court stayed its injunction shall sponte, which means on his own. The state did not ask for a 30-day stay, suggesting that it would have appropriately considered the merits of a motion for a stay pending appeal had the state bothered to ask. The plaintiffs say, instead, the state rushed to the appeals court, seeking it should have first sought below. The state has not even tried to show that seeking that relief from the district court would be impracticable. The state likewise identifies no basis to reject the district court's findings. The arms Illinois banned are distinct from military weapons like M16s and exclusively or predominantly used in military service. They go on to say that the state accuses the district court of failing to consider evidence, concluding that the AR-15 and M16 are not at all the same weapon. In fact, the district court issued a nearly 170-page decision discussing the parties' arguments and evidence in great detail. The district court even cited that very evidence of muzzle velocity, rate of fire, accuracy, and projective penetration that the state mysteriously claims the court never reviewed. It goes on to say the court also relied, for example, on evidence demonstrating that military-issued weapons like M16 and M4 are subject to exact standards of military specificity and rigorous quality issuance inspections, whereas semi-automatic only fire, like the AR-15, are not, and is considered the undisputed evidence that the AR-15, unlike the M16 and M4, has never been used by any military force on the planet. Plaintiffs go on to say, simply put, the district courts came to the common sense and the record-backed conclusion that firearms cannot be exclusively or predominantly useful in military services. In fact, not used in military service because it lacks features the military considers critical. Plaintiffs go on to say, as one would expect, in a contest between law-abiding citizens' ability to exercise constitutional rights and the state's interest in enforcing a new restriction on those recently vindicated rights, the remaining factors strongly favor leaving the district court's injunction and the status quo that prevailed in Illinois for decades under PICA came along in place. Indeed, it is the square law of this circuit that infringements of the rights to possess firearms for protection inflict irreparable injury. That's quoting a case of Ezell v. City of Chicago. The state argues that those constitutional injuries do not matter because plaintiffs can obtain a wide range of other weapons for self-defense, but the plaintiffs say the Supreme Court has expressly rejected that argument, that it is permissible to ban the possession of one type of protected firearm so long as the possession of other firearms is allowed. That's a quote from Heller. So it goes on to, and I'm just scrolling through this. I'm reading from my notes rather than directly from the 30-page filing here. But they go on to say, to conclude, we'll pull that up here so you can see this. They go on to say, finally, the district court's injunction is not unbounded, as the state suggests. It applies only to PICA's enforcement against citizens in Illinois who wish to exercise their Second Amendment rights. To the extent that there is any issue with the clarity of the district court's injunction that supports only this court's suggestion for a limited remand so the district court may expedite its judgment, the district courts would undoubtedly extend the 30-day stay it has already entered if such a remand were to take place. So that does nothing to show that the equitable factors tilt in favor of granting the state's premature motion for a stay in this court. So therefore, they say that the court should deny any defendant's applicant's motion. Respectfully submitted. So there you go. That's the latest in the back and forth here. We'll be watching for today if anything else is filed in this appeals court, the 7th Circuit U.S. Court of Appeals. But we're also still watching to see what the U.S. Supreme Court will do with the case challenging Maryland's gun ban, because clearly that as well is something that is impacting things across the country and what direction they ultimately go with the U.S. Supreme Court in Maryland's gun ban, because that is much more advanced in this judicial system to get some kind of final result. So things still moving here, all right? So that's the latest here. Friday, you had the plaintiffs file their response to the state's motion for a stay of the district court's ruling, while December 9th is the day that the stay is going to be gone if nothing happens with the appeals court. That's coming up. It's December 2nd. Good morning. Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Stay up to date with us here with Illinois in Focus Daily and The Center Square. Get the headlines at thecentersquare.com.